I think we're going to go ahead and get started. Welcome, everyone. My name is Sarah Brennes. I'm the program director with the Refugee and Immigrant Program at the Advocates for Human Rights. And this is a training we hold for those interested in learning about asylum law and for those of you who are interested and able to potentially volunteer with us on an asylum claim at some point. So the general outline for the morning, we're going to talk about the substantive asylum law to give you an introduction to where asylum law comes from and some of the criteria that folks have to meet in order to qualify for asylum here in the United States. And that will mostly be on the PowerPoint, and then we'll work through some of the other documents in the table of contents to get a little more familiar with some of the materials that are typically included in an asylum claim, including the application itself, the affidavit, and then talking about some of the supporting documentation that can be really critical to a claim. So I think we have a small enough group. Maybe we can just go around, and if you'd like to introduce yourself, and if you do have prior experience with, thank you, with asylum law or volunteered with us in the past, let us know a little bit where you're coming from. So, you want to start up here?
Pro bono asylum cases, and here was the CLE, so I
Excellent.
over, so good opportunity.
Wonderful. And do you know which you're working on? One of the recently accepted cases?
Not sure.
Okay. Yeah, just getting started. I don't think we've even got all the materials to you yet. Yeah, wonderful.
I'm Larry Philbin. I'm working with the Advocates this summer on the Refugee and Immigrant Program. I got into asylum law through the Asylum Law Project at the U of M. It's a program where they just send you out to detention centers across the U.S. and have you work with asylum seekers. So.
Okay.
I'm Wade Adamson. I'm also from Great Plant Moody. Just recently started working on my first asylum case. So taking advantage of the CLE that
Great.
Came at the exact same time.
Wonderful.
Hi, I'm Meg Sayer. I'm also from Great Plant Moody, and I have no prior experience, but I'm looking forward to jumping on one of these asylum teams as well.
Wonderful.
I'm Amanda McAllister. I'm a summer associate at Great Plant Moody, and I was also part of the Asylum Law Project at the
Wonderful. I'm going to hop in the back.
I'm Marcy Harris. I'm on the State Bar Immigrant Council.
Oh, wonderful.
And I've done other work relative to low-income clients, and this is an area of need, so I'm
Wonderful. Welcome.
Well, my name is Carla, and I'm a volunteer for that.
My name is Blake Traylor, and I'm not an attorney. I'm here to represent a young woman who came to live with me through an ELS program and found out that she was actually seeking asylum, so I'm working with her. Advocates too.
I'm Steve Shackman. I retired about 5 years ago. I had done one volunteer asylum case in the 90s through the Advocates. And after I retired, my wife and I took up being snowbirds in Tucson, Arizona in the winter, and discovered this past winter there's quite a need for people to do pro bono work in the federal immigration court. So I'm trying to both keep my Minnesota license, which is what it takes to appear before the immigration court. So here for the CLEs, and bonus of this being exactly what I need to learn more about just makes it a great day for me.
Great. Well, thank you, everyone. And feel free, hopefully we can get through everything, but really the goal is so it's useful to you that you walk away with more knowledge about asylum than you came in, so feel free to ask questions as we go. So for those of you who aren't familiar with the Advocates for Human Rights, just give you a little overview. We've been around for over 30 years, a nonprofit. We were started by a group of lawyers, but really our work is driven by the Universal Declaration for Human Rights, and really focus on engaging volunteers in the human rights movement. So all of our programs engage volunteers at some level. many attorneys, but also interpreters and teachers and law enforcement, depending on the project that we're working on. We have most of our programs do more broad-based advocacy work. We work with our women's program, for example, works with partner organizations in Eastern Europe to promote and implement laws against domestic violence. And so once a law has been passed, we also bring over prosecutors and judges and law enforcement to help train on the new laws that might be there and do fact-finding at the front end to see what the situation is and give information to our partner organizations there so they can help advocate. We also work on human trafficking issues both on an international level and nationally and locally. We were involved in the Safe Harbor bill that worked to decriminalize prostitution for 16 and 17-year-olds, and just did a training earlier this week on human trafficking, both from sort of a criminal enforcement perspective as well as an immigration perspective for foreign-born victims of trafficking. We have an international justice program that does a lot of advocacy at the United Nations. We do shadow reports with partner organizations on different countries and human rights abuses. We also work with diaspora communities here in the United States and specifically in Minnesota to help them continue their human rights work after they've had to flee their countries of origin. We have a research, education, and advocacy program that has done work on implementing changes to curriculum, in incorporating human rights principles in the classroom, helping teachers have tools so they can talk about human rights, talk about immigration issues, and other things. And then also have done some research throughout Minnesota about how welcoming our communities are throughout Minnesota to new immigrants, and are just about to publish a report on labor trafficking throughout the state and how our state is responding to labor trafficking. And then our refugee and immigrant program is the one program in our organization that provides direct legal services. So the bulk of our volunteers are attorneys and support staff that work on legal cases, as well as a broad pool of interpreters that help with the legal representation and providing interpretation. And we also have, while we focus on legal services, many of our clients have a great deal of social service needs because they are so limited. We are one of the only countries that restricts access to public benefits to asylum seekers and has a long waiting period before anyone's even eligible to work. So folks are often left without an ability to support themselves and not have a safety net. So those social service referrals are really, really critical. And we've had a social work intern that's been working with us the past several years to help provide direct referrals for our clients, as well as look at some of the more policy level questions and how our asylum seeker clients can access the support they need throughout the process. We have about 500 open asylum cases currently at various stages. One of the things that we've been working on, specifically related to the volunteer aspect, is knowing that at one level there's a group of our clients who are on a very fast track for their cases to be heard, and then there's another group that are on a very slow track, and so the waits are very long. So really trying to work to figure out how to engage volunteers in the most meaningful way possible, and get the clients the services they need. So some of the things some cases will pair with an attorney and they'll see it through start to finish. And then other cases we might have volunteers working on the brief or working on some part of the case. So that's a constant revision that we're doing as we face growing backlogs in the asylum process. So I think one of the first things when we talk about asylum and refugees and how are they the same, how are they different, the first page actually of the table of contents handout has this document by Human Rights First, an organization out in New York, that put together this really great flow chart that just gives you kind of an overview of how refugees come into the United States. And really, essentially, Those seeking asylum in the United States are people that have not yet been recognized as refugees by the United States government. So the definition is essentially the same, but it's just at what point are you going through the process to be recognized as a refugee. So a few of the processes are outlined here. The refugee resettlement process is probably the one most people are familiar with. We have a number of refugee resettlement agencies that would work with people who are identified as refugees outside of the United States and then are resettled here. That makes up that we don't work with that population because those agencies are specifically trained and work with the Department of State and the other agencies to help people that have been recognized as refugees get resettled here. But all the other columns, B, C, D, are people that would potentially be our clients because they're people that have come into the United States. Maybe they come on a visitor visa or a student visa, or they enter the United States without inspection. And then they're able to go through an affirmative process with the U.S. government to make that application for asylum to be ultimately recognized as a refugee. The next process under C is a specific process for arriving aliens. So people who either are apprehended at our border or ports of entry, or they present themselves and they seek asylum. They're subject to expedited removal, so unless they express a fear of returning to their country, they would be immediately sent back to the home country. But if they do express a fear, then they go through a screening process, and if they pass that, sort of a lower threshold of, well, you might have an asylum claim, then they're referred to an immigration judge and put in removal proceedings, but they can request asylum at that time.
Sarah, do you want questions?
Yeah, go ahead.
This credible fear interview.
Yep.
Category C, is that something done at the port of entry immediately?
Typically, yes. It's sort of fluctuated. There was due to staffing, there have been some cases where people are released and then have an interview later, but typically they're supposed to be interviewed at the border. Generally, people are detained until they pass that credible fear interview and then might be paroled in. What we've seen the past few years is a growing number of people seeking asylum at the border, so there have been different responses by the government, sometimes letting people in and having the credible fear interviews later, other times holding them in family detention centers for an extended period of time during the wait. But typically that's done, and usually we wouldn't engage on a case until someone's passed the credible fear interview. If people are one of the few that have been released and then they'd have an interview later, maybe we would accompany them. But generally that's how it works. And then the defensive asylum process is for those that are in the United States, maybe they came in another status or no status at all, and then are apprehended by the Immigration Service, put in removal proceedings, and they could ask for asylum at that point. So I would say the majority of cases are probably affirmative, but particularly in the past couple of years with the growing number of people seeking asylum at the border, we have more of those who are in that category C, where they would be removal proceedings. So we'll revisit process in a little more detail, but I just wanted to give you that as kind of an overview to understand where people might be in the process. Okay, so I think we covered that with the other charge. Yeah, go ahead.
Both have some type of status? Categories?
So for B, they might have status. If someone comes in as a visitor, they usually are given about 6 months typically. If they come in as a student, so long as they're in student status. So some people might, but though I would say the majority of our clients at some point in the process will have fallen out of status. And you're treated a little differently in the process. At the decision time, if you're in some sort of status, you don't lose that status if you're not granted asylum. But if you're no longer in status, then you are put in removal proceedings. And those that are arriving asylum seekers, they might be given parole, which is not a real official, it's sort of you can be here while you're in proceedings, but not a formal legal status. Good question. So sources of asylum law. Asylum is one of the areas of immigration law that really does come from roots in international law, specifically from the 1951 Refugee Convention and the subsequent 1967 Protocol. And then it was the Refugee Act of 1980 was really when it was formally brought into domestic U.S. law, and that's where the starting point is in analyzing any asylum case under Section 208 of the Immigration and Nationality Act, and codified in 8 Code of Federal Regulations, Section 208. So really, that's where you would go to first, and then there's a deep well of case law related to asylum, and then also to some extent, even though there are deep roots in international law, definitely not given as much weight as we would like it to in some instances when cases are being adjudicated. There is, most of the case law would be from published decisions from the Board of Immigration Appeals, which is the appeal board after the immigration court, and then the respective circuit laws. So you go straight from the Board of Immigration Appeals up to the circuit level. The federal courts are sometimes involved in mandamus action or habeas petitions in immigration cases, but otherwise not as specifically. So the definition of asylum, this is sort of we've got the text version and then a more visual version. But it's essentially asking for asylum is asking to be recognized as a refugee and qualifying under the refugee definition as anyone who's outside of their country of nationality. In the case of a person having no nationalities, outside the country of last habitual residence, who's unable or unwilling to return to or avail themselves of the protection of that country because of, and here's the very key language, persecution or well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So, breaking that down into more manageable pieces, essentially the key components for someone to receive asylum, be recognized as a refugee, is being outside of their country of nationality, which for the asylees are here, having a well-founded fear of persecution. And under our case law, that's about a 1 in 10 chance that you would be persecuted if you went back to your home country. We'll talk a little bit later about the burden shifting, but from the starting point, the burden is on the applicant to prove that they meet all of the elements. And then very importantly, the harm that someone suffers has to be on account of. There needs to be a nexus between the harm and their race, religion, nationality, social group, or political opinion. So they need to establish that they are independently belong to one of these protected groups, and that in fact is one of the central reasons that they are being targeted. And then finally, they need to show that the government cannot or will not protect them, either because the government is the one who's persecuting them, or the government has been ineffective in protecting them from the harm that they fear. Okay, so persecution is not statutorily defined, but our case law tells us that it is defined as the infliction of death, torture, injury to one's person or freedom. There is case law that says being beaten a few times, even being detained for a few days, would not rise to the level of persecution. And it is more than harassment or discrimination. However, there can be cases where cumulative harm, so maybe there's not one incident that would be severe enough to rise to the level of persecution, but a number of lesser incidents over time would constitute persecution when seen cumulatively. We often might see this in cases involving sexual orientation, where there wasn't one extreme incident of harm that would rise to the level of persecution, but there was harm that went on for years, repeatedly, that did rise to the level of persecution when seen altogether, or in some of our cases involving domestic violence, if there wasn't one specific incident, but a combination of incidents might rise to the level of persecution. And then the other important thing to remember is that there need not be punitive or malignant intent on the part of the persecutor. So, for example, if there's a case involving a woman who experienced female genital mutilation as a part of a cultural ritual in the country, where the intent of the community was to initiate them into the person's culture, but in fact the woman saw it as harmful to her, that would constitute persecution. So next, when we're looking at well-founded fear, there are two components to that. One, the subjective fear. Does the person actually have a fear of returning? Is it genuine? General, don't like the country, don't like what's going on, is insufficient. It has to be an actual fear of harm. And importantly, just really liking living in the United States isn't going to be sufficient. That usually isn't a hurdle often in our cases. There are a few that would likely be screened out if there wasn't a more significant harm that was feared in a particular case. But most of our focus ends up being on proving whether or not the fear is objective. And that's going to really be where a lot of the supporting documentation is going to be important in a case, and showing, what are the facts that the applicant is providing in terms of the testimony, showing that the fear that they have is real, and that the acts that they fear would actually be carried out. It's also very important to have country condition information. The Department of State has a human rights report that they put out on each country every year. And that's usually the starting point for adjudicators to understand how different groups are being treated. They'll talk about political opponents, women, minority groups, and kind of give an overview of different human rights abuses that may have occurred in the country. So that's usually a starting point. In immigration law, it is a pretty wide open free-for-all in terms of evidence that you might provide. The rules of evidence do not apply as they do in other state and federal courts, and the only thing that the immigration judge has explicitly said they will not accept is anything from Wikipedia. But other than that, and now with internet, there's a lot of information that people can gather, and certainly some international media sources or more well-known human rights organization, human rights Amnesty International, and those organizations that put out reports on different countries, they're probably going to be given a little more weight than a blog post by some random person. But you're not prohibited from providing it, and the adjudicator will give it the weight they deem appropriate if it's not specifically excluded. That tends to be where things settle. But keeping in mind your source is important, but really sort of casting that net broadly when you're thinking of documentation to show that the fear is objectively reasonable. And basically the standard is a reasonable person in the applicant's circumstance would fear the harm that they are in fact afraid of. Then the next important element is looking at government protection. When the government is the one who is the persecutor, it's a little easier to show that they are not going to protect you because they are the ones who are harming you. And that would be either because there was some specific past harm, you were held in a detention facility and tortured by obvious government officials, that would certainly show that they would not be willing to protect you. But it also could be a pattern or practice of persecution. These are a little more difficult cases to show, but if you can show that there is a pattern or practice of persecution for a group that you are a member of, even if you had not been targeted specifically, that may also establish that the government is the persecutor and would not be able to protect you or be willing to protect you. Other cases that involve a persecutor that's not a government actor, you would need to show either you ask the government, the applicant asked the government for help and they refused to help you, or the help they did provide was less than adequate, or that you didn't ask for help because you knew it would be futile, or you knew that it was going to bring you worse consequences because there's not adequate laws or policies on the books, or if there are laws and policies on the books but they're not adequately enforced, that would be another means of showing that you could not get government protection. So we see this often in domestic violence-based cases where the victim either didn't ask for help from the government because the persecutor had connections or knew that they could bribe law enforcement, and they would end up in a worse situation after reporting the incident, or that they went and they made a complaint and they were told that, well, it's a family issue and you should resolve it with your partner. We're not going to get involved. The government doesn't get involved in family matters, which happens in some countries. And again, this would be both a combination, and we'll talk about the domestic violence case specifically in a little bit, but a combination of both testimony from your client as well as that supporting documentation to show that what your client's saying fits in with documentation about the country. I want to take a moment to talk about the burden shift now. When there is, as I said, the burden rests with the applicant to establish that they meet all the elements of the claim. If the applicant can establish that they were persecuted in the past, if you have a clear situation, the applicant underwent female genital mutilation, was raped, was clearly tortured, those cases might establish very well that there was past persecution. And then if that's true, there is a rebuttable presumption that they would be persecuted in the future. So at that point, the burden would shift to the government to show that either there's been changed circumstances, maybe there's been a change in the regime and now the political party your client belonged to is part of some coalition government, or there's some specific situation in the client's life or the home country that's makes it such that the fear is no longer well-founded. The other thing they can show is that it's reasonable for the person to relocate to another part of the country. Now, what's important to remember about reasonable relocation is that it's broader than the applicant being found by the persecutor. So certainly that's a relevant factor if they've tried to relocate and the persecutor has found them. But you don't need to show that the persecutor would find them anywhere in the country. The regulations give a more broad brush to what's considered reasonable relocation, taking into account age, gender, social strife, other factors that would make it unreasonable for them to go to another part of the country. And so that cultural context is important too. If it's a country, if it's a female client and it's a country where it'd be very difficult for a female to live on their own and be away from family, and the persecutor is where their family is, that would factor into considering reasonable relocation. Also the size of the country. If you're talking about Togo, is very different than if you're talking about Democratic Republic of Congo. And the other thing to keep in mind is if the government is the persecutor, it's presumed to be unreasonable because the government is everywhere. Did you have a question?
Is asylum limited to certain countries?
No, anyone can seek asylum in the United States. You could try to. There's very few cases from Canada, but certainly you can apply if you have a legitimate claim. Yep. And then, so let's say the government does meet that burden, then it shifts back to the applicant, and they can still qualify for asylum under one of the two categories that's considered humanitarian asylum. So they either establish that the persecution they suffered was so severe that they shouldn't be forced to go back, or that they would suffer some other serious harm. And they're very different considerations. The severe past persecution, a couple example cases, there was a client who was a child in Liberia during the war and was locked in a closet while his family was killed. And he came out of the closet and found his family. And the judge didn't find that it was grantable, but the board did and said, because of what this child experienced, the country is a very different place than when the incident occurred, but because of what that child experienced, or now adult, had experienced as a child, he shouldn't have to go back to the country if he doesn't want to. We've also had other cases where, for other serious harm, there was a case involving a client who was from an indigenous community in Guatemala. And the client was a baby when there was a massacre in the town. Her father and other members of their community were killed, and they were forced to live in remote mountainous areas for a number of years, and then went back to the town. Fast forward 20 years, and she's being extorted by the gangs. Tough claim just on the extortion. That's what led to her fleeing to the United States. It's a tough claim on just the extortion claim for an asylum claim, but the judge found that there was persecution in the past when she was a baby, and that the harm that she would suffer is real. Many of the gang-based cases in Central America, the hard part is establishing the nexus and why they're being targeted, and the government says, well, the gangs are targeting everywhere, but the harm is real. The statistics are there that people are being killed. So the judge found that would be other serious harm. The harm has to rise to the level, be as severe as persecution, but it doesn't have to be connected to any of the protected grounds. So that's really significant to keep in mind. And one of the other advances we've seen in the past few years is to see the law consider more than just some physical threat of harm, but if someone had, let's say they had, as a result of their past experiences, have post-traumatic stress disorder, and they're receiving treatment here, and there aren't places for them to be cared for in the home country, that might be other serious harm they would suffer because they couldn't get the care that they needed, or they've got some other medical issue that's completely unrelated to the past claim. Yeah.
In my case, PTSD was identified, but she was functional enough to where they didn't want to re-traumatize her. So what I'm hearing, though, it would have been better for her case had she actually gone through the treatment to have documentation. So I'm just wondering how you work with that one, because definitely had dissociative behaviors and a lot.
But then didn't get treatment, or did get treatment?
It would re-traumatize her.
Oh, okay.
Functional enough. She did have the PTSD, but she was functional enough.
Yeah, I mean, I think that would be a difficult to argue. I mean, perhaps there would be an argument to say going through treatment would re-traumatize, and going back to the home country would re-traumatize, if there were medical documentation that could establish that. What's really important to remember about these, because a lot of times it's tempting to go straight to, oh, well, there is other serious harm, but what you need to establish is past persecution with a nexus to one of the protected classes in order to get to that humanitarian asylum consideration. So you have to go through the whole chutes and ladders of the analysis in order to be able to access that. And as we'll talk about later, there's another type of relief called withholding of removal for people who might not be eligible for asylum, and this humanitarian asylum does not apply to those folks.
Sarah,
Yeah.
I'm guessing that word humanitarian is a term of art. Is it?
Yeah,
What does it
in the
mean?
regulations, it does. It's humanitarian asylum is, and it is a term of art, and being in this specific criteria, it's sort of like, well, humanitarian asylum, this person is a good person and things are difficult back in the home country, so for humanitarian reason we should give them asylum. That's not. Yeah. Good question. Okay, so the other situation would be there's no past persecution, then the burden stays with the applicant throughout to prove everything. That there is a fear of persecution, there's a reasonable possibility that they'd either be singled out for persecution, or there's a pattern of practice of persecution to the group that they belong to, that the government is unable and unwilling to protect them, and that it would be reasonable for them to relocate to another part of the country. I would say most of our cases, there's at least an argument to be made that the past harm constitutes past persecution. And usually for the ones where there's only a fear of future persecution, it's because there was a significant change in the country since the person's come to the U.S. All right, so the protected grounds, as I mentioned, include 5 protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. Most common ones we've seen are religion, political opinion, and membership in a particular social group, which we'll talk about in a little more detail. And the harm that someone fears, their membership in one of these groups has to be at least one central reason that the person is targeted. There can be multiple reasons that they're being targeted, but you need to establish that it's on one of these grounds that's one of the central reasons that they are being targeted. So the persecutor can have mixed motives in targeting the individual, but it's important to make the argument that